Chair calls Megan Courser. Please state your name, who you represent, and your position on this bill.
Good afternoon. My name is Megan Courser. I'm here on behalf of the Texas Homeschool Coalition. We are against the bill. Quick clarification, the bill is discussing mental health screenings, not medical issues. So if a child has a medical problem, that wouldn't be addressed under the bill. So I think a little bit of the testimony has gotten a little bit mixed up. Our concerns with the bill are actually three of them. Our first one is that of parental rights. When a child is removed, the CPS and DFPS have 14 days to come back and show that there was probable cause and that the removal was justified. That happens at the 14-day adversary hearing. Now, the problem with the bill is that it requires the mental health screening to happen within 72 hours. Feasibly, that can happen before the parents have their day in court, before there is due process, before CPS has even proved that the removal was justified in the first place. So obviously there are parental rights problems there. We would want parents' rights to be protected, not have their children screened, and have mental health treatment administered to their child without even their knowledge and without having proven that the removal was justified and that the parents were abusive or neglectful in the first place. Our second concern, which was echoed by Lee and Judy both, was that of inaccurate results of the screening. If you're going to screen a child within 72 hours of them being removed from their home, you're obviously going to get inaccurate results. The child has just been traumatized, so obviously the mental health screening would reflect that, and we don't want the record or the court to reflect the fact that the child is traumatized when obviously they've been traumatized.
1 second. Chairman Coleman.
Thank you very much, Mr. Chairman. I'm curious. Do you consider mental health to be medicine? I'm just asking you a question. I don't know if it's something different in this bill, but mental health, do you consider that to be medicine?
I believe that is a subset of medicine, sure.
Which would make it medicine?
The bill only allows for a mental health assessment, not medical screenings.
Mental health assessment is a medical screening.
A type of it, but does not consent for general medical consent.
So you don't believe that mental illness and psychiatry and psychology and social work and those things are a medical profession?
Personally, I believe they are a subset. The bill only addresses mental health assessments.
It's something you got a whole set here and you have a subset of that. It is part of that whole. That's
sure,
what they
but
teach
the bill
you.
doesn't address issues for if the child has diabetes or has some sort of tube that they have to have. It doesn't address any of those things.
All right. So you don't believe that this is a medical screening. You don't believe it's medicine.
It's for mental health.
Okay, but that's medicine.
I don't believe that it's for medicine in general. I believe medicine would.
But what I mean by that, a part of the medical profession and part of illnesses that we go to providers for. Would you acknowledge that?
Well, the bill does say that a medical or mental health care professional would perform the mental health assessment, if that's what you're referring to.
Okay. So generally, I imagine that already there's some kind of physical that's done on the child or some type of assessment of
that's
the
not in
child's
current statute, no.
General health.
Not within 72 hours, no.
So not within 72 hours when the child is removed from the home.
That is not in current statute. DFPS is allowed to consent for such an examination in the case of emergency medical treatment. That's already in statute, but there's no requirement or allowance in statute for DFPS to conduct a complete medical examination of a child within 72 hours, no.
Well, a checkup.
There's no requirement or allowance for that within statute, except for cases when there's an emergency and they need to examine the child.
So the assessment itself as part of a medical assessment, even if it wasn't in 72 hours, would that be something that is something we shouldn't do?
Not within 72 hours. As I already stated, the parents haven't had their day in court. The CPS hasn't proved that the removal was justified in the first place. There are obviously a lot of due process problems with that. Because it's a mental health screening, obviously if it's an emergency, then DFPS already has the authority to consent for such a medical examination, or in this case, mental health assessment. But current statute does not allow them to unilaterally conduct mental health assessments within 72 hours of a removal.
Okay, thank you.
Okay. And I had one further point. Is it okay if I continue with that?
Sure.
Okay, wonderful. My third and final point is that of evidence gathering. This is something Judy also talked about. We are concerned that in certain cases, CPS may not have had the evidence needed to remove the child and prove probable cause or justifiable cause to remove the child in the first place, and that these mental health screenings could be treated as essentially evidence gathering missions to say, oh, the child is mentally traumatized. It must be the parent's fault, not the fault of the removal or any of that the child is now enduring. So we obviously would like that to not be included. There's no requirement in the bill that such a medical assessment or mental health screening could not be used as evidence at the adversary hearing. It was gathered after the removal, and again, the child is obviously traumatized. We don't want those things to be counted against the parents and inadvertently harm parental rights in the process. And with that, I would conclude my testimony. If there are any questions, I'd be happy to answer them.